Hi, I'm Greg Dell with attorneys Dell and Schaefer, and today attorney Stephen Jessup and I are going to discuss a recent case out of the Federal District Court in Oklahoma. It's not a case that our firm handled, but like we always track all the cases around the country because it benefits our cases and it benefits obviously our clients so that we always know what's going on with these other insurance companies. So this was a case against the Aetna Disability Insurance Company, and if you can tell us the background and we can talk about some of the issues that would benefit some of the people interested in learning more about Aetna.
All right, so this case was interesting, and I think it's an experience that a lot of insureds will have, especially going from a short-term disability claim to a long-term disability claim. In this situation, the insured, she worked as a dental sales, office equipment sales, things like that. She suffered from dyslexia, hearing and visual impairments, ADHD, anxiety, issues along those lines. And she'd been able to work with it for some time, but then her company had changed out all the software and hardware they were using for data entry and all that. And because of her impairments, it was too hard for her to adjust to that new system. So her doctors recommended she go out of work. She filed the claim for short-term disability. Aetna was acting as the administrator of the employer's short-term policy. So what that means is Aetna isn't paying the benefit, they are just telling the employer that the benefit should be paid at that time. And then Aetna underwrote the long term, so that means Aetna was going to pay the benefit out of their own pockets. So Aetna reviews the claim, they approve it without issue, but when the time comes for long-term disability, they have a whole new panel of doctors review everything. And the doctors for long-term disability determined that there was no evidence that Ms. Redden would have been disabled from the date she went out of work through the elimination period. And that is the short-term disability period. This directly contradicts what their short-term disability doctors say, so it seems like common sense that they messed this one up. She filed her appeal. Aetna upheld the denial of benefits, and then a lawsuit was filed after that. And the court, after quite a bit of lambasting of Aetna, ruled in her favor that Aetna got it wrong.
Okay, so usually what we'll see, well, it varies. Sometimes we'll see a different company do short-term than the long-term, and then that's why maybe the long-term has a difference of opinion. And here it was like, hey, you approved on short-term, and then your reason isn't, you would expect the reason to be you got better after the 90 days or 180 days of short-term disability, but here they're saying you were never disabled from the beginning. So what was the court's take on that?
I mean, the court was very critical and didn't mince words, about how contradictory and illogical it would be for Aetna to rely on the opinions on long-term that was completely opposite of what their doctors had reviewed for short-term, completely opposite of the clients. Like you said, if it was their new doctor said, oh, we think she would have recovered to a point she doesn't need it, that's one thing. But the judge really laid into him. And then Aetna tried to make the argument, well, she had been able to work for 2 years with these problems, so what changed? Which opened up the court again on another line of argument against Aetna's review, basically how the medical records were very, very well documented about the changes at her work environment and how it was causing problems with, due to her conditions. The court was not having it. And this was an arbitrary and capricious review. The court just, basically, Aetna just had to show, hey, we gave her a reasonable review at the end of the day. And the court said that it was no way, in any shape or form, a reasonable review of her claim.
And what does that mean when you say an arbitrary and capricious review?
It means with that, so when it's arbitrary and capricious, as a plaintiff, you have 2 steps to prove in trial, even though it's not really trial under these ERISA policies. One, you have to show to the court that you're disabled. If the court finds that there's enough information to support disability, the second step is whether or not the insurance company acted arbitrary and capricious in denying the claim. A lot of courts, the way they kind of interpret this standard is, did they provide a reasonable review? Was there a reasonable basis? I mean, courts will say, hey, you had some doctors look at it. They disagreed with the person's treating doctors. That's okay if you relied on their opinion, so I have to uphold your decision. So it's very, very, very favorable to the insurance company, and historically they win the overwhelming number of cases that fall under that standard of review that the court will use. So here, even with that, the court was not having it,
The court issued a 40-page opinion, which is pretty extensive for this kind of case. And you said this case went back to 2008.
I actually double-checked the actual ruling just to make sure that there wasn't any typos, and went back to 2008. So there was definitely a lot going on with lapses and what took so long to get it into court. So once the judge made the ruling, I mean, it was just this past month. It was in September of 2018. We're talking a long time after the fact. A little bit, I wouldn't say insult to injury, but part of the problem was too is because of her conditions, the court did agree with Aetna of the imposition of the 24-month limitation for mental health conditions. So she was awarded her benefits, but just capped at that 24-month period.
Right. Someone shouldn't think that it takes 10 years to litigate a case, because that's highly unusual. I mean, usually the average is about 18 months, give or take, so don't think it's going to take 10 years. This was exceptional. Was there anything you saw in the opinion that you thought could have avoided maybe on the appeal? Did the claimant do their own appeal, were you able to tell, or was there something that could have been done differently on the appeal to possibly have won and avoid the lawsuit?
Honestly, in this one, I don't know. I don't think so, because the support that her doctors wrote her, I mean, very well documented medical history, from the behavioral health side to the issues with the dyslexia and all. I mean, it was very well documented and argued. It's just Aetna, I think they were in their mindset, we're just going to deny. And that's all we're going to do. We'll see if they bother to fight us, whatever the case may be. It was really, really poor claims handling that typically you wouldn't see from a large insurance company like that. They usually know how to cross their T's and dot their I's. This could also be a product of the fact that it happened, a decade ago. And with the kind of the evolution of ERISA disability policies, regulation changes, companies being, fined, the insurance companies have, increased their crossing of T's and dotting of I's on their reviews.
Right, and important to keep in mind now that I believe it's Hartford that acquired Aetna.
Yeah, their life and disability products.
So now all of the Aetna claims are going to be handled by Hartford, which is important to know too if you're watching this video and have an old Aetna claim, that now it's going to be administered by Hartford. So,
or if your employer has an Aetna policy, when it's due up for renewal, more than likely be now a Hartford policy.
Okay. So if you have an issue with an older Aetna policy or the Hartford Disability Insurance Company or any long-term disability insurance carrier, feel free to call any of our disability attorneys. We're available to help you anywhere in the country, and we always offer a free initial phone consultation.